Welcome. Welcome, everybody. I'm going to give you a moment for everybody to kind of get into the room and we can start this webinar. I want to welcome you to the first of our webinar series, which we're calling Evolve. And it is a series designed to help give more information, education about the divorce process. The one we're going to do today, this one's called Divorce 101, Understanding the California Divorce Process. We understand that divorce can feel very overwhelming, stressful. You're in a world that you don't know, you're not familiar with. And our job here, sorry about that. Our job here is to help bring clarity to that process, to help reduce the chaos and overwhelm of divorce so you can focus on building a better life. All right, so I'm going to introduce myself. I am Shelley John. I am the founder and owner of Family Law Revolution and the Law Office of Shelley Jean John. I have been helping families through divorce and child custody disputes for over 28 years with my office in Southern California. And we are a growing office and we really cherish helping people. I hire people who love helping people, and that's what we're here to do for you today. I see some familiar faces and some names, some current and past clients. I just want to remind everybody that today is about general information. So if you have a specific question about your case, you can meet up with us later. But if you have general questions as we go through this, feel free to put them in the chat and I will do my best to get to them before the end. We're going to go really fast. There is a lot to cover. Like I said, we are here to educate you. We believe that education builds confidence, and we want to help you with that. What you're going to learn today, how the divorce process works, child custody and visitation basics, the basics of child and spousal support, and then a little bit on how to stay organized and a little bit on how to reduce your stress. Understanding the divorce process in California. In every state, the divorce process is a legal process. There are defined stages of the process. There are very specific requirements as you go through that process, and there are timelines, deadlines that you have to meet. Some of those timelines are going to be predictable, and unfortunately, some of them are unpredictable. Divorce cases can take 1 month to years and years and years, and it's going to depend on how much conflict there is between you and your spouse and how much time you need to spend in that court process. So here's just a very simplistic roadmap for the divorce timeline. You'll see up in the right, it indicates that you can file a request for a temporary order at any point in the process. The courts understand that the timeline from when the divorce starts to when it is finally finished can take, sometimes, like I said, it can take years. And they understand that you need to have visitation orders for the kids. Sometimes you need support orders. Sometimes we'll talk about the different kinds of temporary orders that you can get, but those can kind of be peppered in throughout this process. So the divorce process starts by filing a petition. This is the document that gets filed with the court. You get assigned a case number, and that is what starts the divorce process. The next step is the filing of the response. The respondent, so the person who files the divorce in California is called the petitioner. The one who responds is the respondent. They have to file their response. There are some limited exceptions when there are agreements regarding all of the terms that would divide up your property and assets and the kids and stuff. But generally speaking, plan on having to get that response filed within 30 days. The next stage are disclosures. This is the exchange of financial information so that you both understand all of the assets and the value and the debts and the income and the expenses. And we'll talk more about that disclosure stage as well. The discovery stage, this is where you're gathering evidence. Sometimes you're gathering evidence because you want to make a settlement proposal and you need more data, or you want to accept a proposal and you need more data. But other times you're gathering that evidence so that if this case goes to trial, you have documents to show the judge why he or she should grant what you're requesting. Then you go into the negotiation stage. Now, the negotiation stage can actually happen at any point during the divorce, but there are definite points in the divorce process. Sorry, let me get a little water. There are definite points in the divorce process where the court is going to require that both parties and both attorneys, if you have them, are going to work on settlement. If you can't get to agreements, or sometimes you can arrive at 10 agreements, but there are still 5 things that you're still disputing, then you would go to a trial. And a trial is where a stranger in a black robe makes a decision about your life. And that's not always the best way to go, but sometimes it's the only way to go. So filing for divorce, I indicated you're first going to file petition documents. There are a lot of documents and forms that you have to fill out that you then file with the court. You pay your filing fee. The next step, once you get those documents back from the courthouse, is you're going to serve your spouse. 90% of the time, you have to have them personally served, which means that a person who is not you has to go up to them and hand them the papers. There are some circumstances where you guys are getting along, and there are some agreements where the person receiving the paperwork can just have it mailed to them and they can sign a form. But plan on having them personally served. Sending it in the mail without that written acknowledgement is not going to get you anywhere, and you're going to stay stuck and not be able to move forward. The filing of the petition starts the timeline. It really actually starts from the time that you serve the respondent. That is when that 6-month timeline that you've all heard about starts. What is that 6-month timeline? It means that the marital status, you becoming an actual divorced person, cannot happen unless and until that 6-month mark has passed from the date that the respondent received the paperwork. You can enter into agreements. The court can make orders. You can even have a full judgment, and that can all start to take effect before that 6-month mark, but you're not technically divorced until that 6-month mark. Now, that 6-month mark might be extended if you guys don't have a judgment that terminates that marital status. So that is very important. The case starts with a petition and it ends with a judgment. And then there's also those disclosures, and we'll talk about that, but they're supposed to be served on the other party within 60 days of filing the petition or 30 days of the response. So if you're responding to divorce papers, it is important that you understand the requirements. And for both of you, whether you're the petitioner or the respondent, on the summons, which is one of the documents that goes with that petition, it lists out what are called automatic temporary restraining orders. We refer to them as ATROs. In that, it indicates you cannot remove the child from the state of California without an agreement of the other party. You cannot transfer or dispose any property without agreement of the other party. That means property purchased or acquired during the marriage. It also means separate property, anything that you acquired before or after the marriage. You're not to dispose or transfer any of that without agreement of the other side. You're not allowed to cancel insurance, car insurance, health insurance. You can't change beneficiaries. There's a lot of rules on there. So be sure to look at that summons to understand what your obligations are, as well as the obligations of your spouse. If you're responding to a divorce, be sure to adhere to those strict deadlines that I mentioned. That 30-day mark is really important. We talked about the disclosures. Default judgments. What can happen if the respondent does not file and serve their response within 30 days? The court can take their default, which means that the court can say, we're going to make all the orders that the petitioner is requesting because the respondent hasn't showed up. And I mean shown up by paperwork. So to avoid that default, make sure that you follow those deadlines. We talked about financial disclosures. This is where I really want to drive home that point. The court requires transparency, that both parties fully disclose all financial information, including assets, debts, income, and expenses. It is all because of this family code here, Family Code 2100C. It requires a full and accurate disclosure of all assets and liabilities. And again, whether it's owned by both of you or just one of you. And all of that is supposed to be disclosed at the early stages of the divorce, regardless of the characterization, whether it's community is joint property purchased or acquired during the marriage, or whether it is separate property. That is property that was acquired prior to marriage or after separation or by inheritance or gift. And you are also required to disclose all of your income and your expenses. This is pay stubs, tax returns, and that you have a continuing duty to do this. The court says the reason for this is so that at the time the parties enter into an agreement for the resolution of any issues, or at the time of trial, each party will have a full and complete knowledge of the relevant underlying facts. In some cases, you already know all the information. Both parties know the information. And in some cases, you don't. Whether everybody knows or everybody doesn't know, you have to do these disclosures. If the case goes to court, so first understand, most cases do not go to a full trial. Most cases, by the time we get to a judgment, are settled by agreement. But there are those cases that have to go to trial. And that is where you present evidence and testimony. So I want to distinguish here between hearings and trials. A hearing is where the court will listen to what we call oral argument. They'll listen to the attorneys, we'll make our case, they'll decide what should happen on these temporary orders, and they'll make a ruling. A trial is where the witnesses actually have to testify. So this is where we provide the physical evidence, any documents, any witness testimony. So it might be the testimony of the parties, or it might be third-party witnesses that you bring in and they testify in front of the judge. And this is where the judge will then make their decision, is at that trial. The judges make the final decision, and when they do, it is legally binding. So even if you don't agree with it, the judge, the decisions that stranger in a black robe makes, you must adhere to. And at the time that you go to a final trial, the court should be deciding on any division of property, who's going to get what, any equalization payment, who owes the other party money, who's going to pay which debts, where the kids are going to live, whom they're going to visit and when, how much, if any, child support or spousal support will be ordered, and whether any attorney fees are going to be ordered payable from one party to the other. Trial is very expensive. To get to trial can cost tens of thousands of dollars and upwards, depending on where you are in California. So understand that when you're thinking about whether you want to just have the judge make the decision or whether you want to really consider working on a negotiated agreement, because it takes its toll on people. It costs money, it costs energy, and as I said, it's unpredictable. You have to understand, this stranger in a black robe that I keep referring to, this judge, they're human. And they may have gotten up on the wrong side of the bed that morning. They may have preconceived notions and biases about certain aspects of maybe a child custody case or about a support case, and you don't know. So to try to keep that control within your hands, you really want to work on an agreement. But that's why trial can be unpredictable. Yes, there are laws that they have to follow, but in family law, a lot is left up to what they call the discretion of the judge, which means that the judge has a lot of latitude to make orders based on what they see fit. Okay, temporary orders. As I said, while your case is going on, the court can make some temporary orders. The types of temporary orders that they make are ones related to the kids. It can do, they can establish a child custody schedule, visitation, child support, things that are going to ensure the child's well-being throughout this process. They can make orders for spousal support, temporary spousal support orders to get each person through until the divorce, when the assets can be divided and the court can consider how much spousal support, if any, would be ordered in the future. They can make temporary orders about property use. Who's going to use which car? Who's going to live in the house? Who's going to run the business? They can make those types of orders on a temporary basis. And then the goal of temporary orders is to try to maintain the status quo, to try to help the kids as best as possible, to make sure that people have the money that they need to support their household and their kids. But that's what temporary orders are for. Another one that I don't have up here is a domestic violence restraining order. Courts can order those at any point in time. And that's a whole separate subject with a lot that goes into it. So I'm not talking about it here, but these are just some of those temporary orders. When we're talking about the kids and understanding child custody, it involves two main components. You have legal custody and you have physical custody. Legal custody refers to the decision-making. Who's going to make decisions about their education, where they go to school, who their tutor is going to be, whether they go to private school or public school, about the kids' health care. That includes selection of doctors, decision on courses of treatment, surgeries, things like that, and then religious instruction. The courts prefer joint legal custody. Even if a parent has very little visitation with the kids, it's not uncommon for courts to say that person should still have a say in how the child is raised. So they prefer joint legal custody unless you can show an extreme reason why the courts wouldn't grant that. Another one is physical custody. This determines where the child lives, where are they going to go to school. Again, generally the courts prefer joint physical custody unless one parent can show why they should have sole or primary custody. The last one there is parenting schedules and visitation. The judges can decide on when the kids are going to see the other parent, the schedules, the transportation. They have a lot of latitude in deciding, holidays and summer schedules. And of course, you and your spouse can agree to these things outside of the eyes of the judge. They can be put into your judgment, and the judge doesn't really care what you guys do for the most part. But if you can't come to agreements, then the judge can make decisions, and these are the three primary ones. The court has to consider what are called the best interests of the child. That is the standard that they have to look at when they're determining what is going to be the best housing or visitation schedule for the kids. They look at the child's relationship with each parent. How closely bonded is the child to each parent? They look at where are they used to living? Where are they used to going to school? How is school going? Any community ties or extracurricular activities that the kids are involved in. The family code says they have to look at, and I put this in quotes because this is what the code says, they have to look at the health, the safety, and the welfare of the child. And I think I may have indicated earlier, the courts have a lot of discretion in making these orders. They have probably more discretion in making orders in family cases, in divorce cases, than they do in other areas of the law, which means that if the judge has a preconceived notion about whether parents should have joint custody, or maybe they think that the mom should have more custody than the dad, you don't know what the judge is thinking when they show up to court that day. But they are supposed to look at all of these things, the health, the safety, and the welfare of the child. I want to talk about child's preference because there's a lot of misunderstanding about that. Some people think that when the child turns 14, they can just decide where they're going to live and who they're going to see and when. And that's not true. What the family code says is that when a child is 14, if they want the court to consider their preference, then the court has to find a way to consider and hear their preference. The court can listen to the preference of kids at any age, but they're going to decide how much weight, how much consideration are they going to give to that child's preference. They look at the age and the maturity of the child. So at 14, the court, they may listen to the child's preference, but they don't have to follow it. Of course, as the kids get older, the judges tend to give more weight to the child's preference, although at no point will they ever say that the kid always gets to just decide. The judge may give the child some latitude on arranging the visitation if they're 16 or 17, but ultimately the parents, if they have an agreement, or the judge get to decide where the child's going to live and how often they're going to visit with the other parent. Child support. Child support in California is based on a mathematical formula, which has been incorporated into software programs. In California, the courts will mostly use the ex-spouse program, but there's a subscription cost to it. So if you are wanting to just run some general numbers, you can go on to the Department of Child Support Services website. I don't have that website for you, but you can Google it. And they have a computer calculation on there you can use. They are going to look at things such as how many kids, how often does the other parent visit, how much money does the other parent make, how much money do you make, how much health insurance either one of you is paying. And as you can see, there's a whole lot of other factors on there that the judge can take into consideration. But all of those numbers, which as attorneys, we argue about what the numbers should be. But once the judge determines what those numbers are, they put them into the calculation and it'll spit out the child support amount. That is called guideline child support. Child support continues until the child is 18 years old or until they're 19 if they are still a full-time high school student. Child support can also include orders regarding who's going to pay the health insurance, unreimbursed medical costs, child care, education costs. They can make other orders in addition to just this main number. Most of the time, they're not going to order that both parties pay extracurricular costs, although sometimes they will do that. Spousal support, and I'm sorry I'm going so fast. I know we're getting close on time. So spousal support, there are two kinds. Temporary spousal support, that is what is ordered until the trial or until the judgment, and what they call permanent spousal support. Now, permanent is not actually permanent. It is not forever spousal support. But permanent spousal support refers to whatever the support amount is that goes into that judgment, and that is the amount that's going to go forward. Sometimes there's a termination date, sometimes there's not. The judges can use that computer calculation that I showed you earlier. They're allowed to use that to determine temporary spousal support. But when they're determining permanent spousal support, they actually have to look at a whole number of factors, and they're not allowed to use that computer calculation. So if you go to Family Code 4320, you'll hear us refer to that as the 4320 factors. You'll see it looks at length of marriage, earnings or ability to earn, the ability of one party to pay, the marital standard of living, the age and health of the parties, assets, how many assets, what's the value of the assets that one party has, or debts. They can consider domestic violence, whether there was a documented history of domestic violence, and they can consider just and reasonable, what they think is just and reasonable. Under Family Code 4330B, that is what we refer to as the Gavron warning. The courts in temporary spousal support, they're trying to just kind of keep as much status quo as possible. In permanent spousal support, the goal is to help get the party, the lower earning party, help give them a head start so that they can start to become self-supporting over time. That Family Code section in the Gavron warning states that the court wants the supported spouse to make reasonable efforts to become self-supporting within a reasonable period of time. All right, we got through all the law very quickly. Of course, there are nuances to all of these things, but this was intended just to be a structure, a framework for you to kind of piece all of these things together. Let's talk about staying organized during the divorce. It is extremely important that you keep everything very organized. There are a lot of papers that you're going to be coming across throughout this process. I encourage you to create a folder on your computer if the other party doesn't have access to it, or Google Drive, or one of those, Dropbox, something like that. It's going to be your divorce folder. And you might have some subfolders such as court papers. Another one can be called evidence. And then you can have another one that has court orders in it. But keep all of that very organized. If you're not that techie, you probably wouldn't be on this webinar today. But if you aren't and you just need paper, then print everything out, keep it in a binder. And then if you're living with your spouse, I would not keep the binder at the house. Keep it with a trusted friend or relative, but keep a copy of everything. Track your deadlines. Stay on top of all court deadlines and dates. So keep a calendar. If it's a written calendar or a computer calendar, keep a calendar so you do not forget. Because if there is a court hearing and you do not show up, the judge can make orders without you. And I'm sure you don't want that. Save all communications. So keep copies of emails, text messages. Text messages, you can do a screenshot to keep a copy of it. People's phones fall in the lake all the time. So make sure that you keep a screenshot and save that in your electronic folder, and try to have the date of the text message in the screenshot in order for the court to be willing to consider it. And then keep notes of your conversations with your former spouse, with your attorneys and other third parties. I know that when I talk to my clients, they might retain maybe 20% of what I say. Just like today, you're not going to retain all of the things we've talked about. That's why it's important to take notes. Keep them somewhere where you can refer to them. And then maintain detailed logs. So keep precise records. Write down in a calendar when you have the kids, when the other parent has the kids, any expenses that you're paying after separation. So if you're paying on expenses that were incurred during the marriage, be sure to keep a really good log of that, because you might be entitled to reimbursement for some of that money. And then significant events. Anything that happens that's of significance, write it down, because if you have an attorney, we're later going to ask you to recall those events when we put them into your declaration, and it's going to be much easier for you if you've been keeping a log the whole time. All right, managing stress within divorce. And we might go a little bit over, I'm going to try not to, but you have to fill your cup before you can give to your kids, to the divorce process, to your job. So take the time to make sure you have a support network of friends or family, people who comfort you and make you feel better. Prioritize self-care. That might be exercise, it might be hobbies, but make sure that you are taking good care and balancing out all of this anxiety that you're going to be feeling throughout this process. Try to maintain daily routines. The divorce process can be unpredictable, and having a routine that you are familiar with can actually bring down your anxiety level and make you feel a little bit more secure every day. Explore professional help. I encourage my clients all the time, sometimes I require it, to get therapy or counseling or meet with somebody from your church. But reach out. If you don't have health insurance, then there are a lot of online apps like betterhelp.com and places where you can go to get therapy to help you manage your anxiety as you go through this process. Because when you're anxious, you're not able to think clearly, and we want you thinking clearly. So whatever it's going to take to help bring that anxiety down. And then leverage community resources. Supporting your children, reassure them that they're going to be okay, and that you're still going to be there, and that the other parent is still going to be there. Do your best to try to avoid avoid conflict if you can, but at a minimum, shield the kids. They should not know about the court process. They should not know about hearing dates. They should not be reading your court papers. Keep them out of it. And then, like I said, a couple of other things. Maintain routines with them. That helps bring their anxiety down. Encourage both parents to have contact with the kids and seek professional help if you need to. Common mistakes to avoid. Do not act out of emotion. Anger is a very bad place for you to make decisions and to take action, and it can 100% come to bite you in the butt. Do not ignore deadlines. Do not have poor communication. I want you to have good quality constructive communication with the other parent. Look up a book by Bill Eddy on Amazon. It's called BIFF. We refer to it as the BIFF method. It's a great way to communicate with your ex or the other parent so that it doesn't escalate into conflict. Don't hide assets. Again, that can bite you in the butt. And if you hide assets, at the end of the day, if it gets found out, the court can actually award 100% of those assets to the other party. So don't hide assets, and don't involve the kids in disputes. All right, next steps. Continue learning. We are going to continue to have this Evolve series. So tune in, watch your email and social media. We will post the link for those times. Seek professional guidance. If you want to talk with my firm, we're always here and available to answer any questions that you have. Meet with your CPA or an accountant if you have questions about the money. And again, emotional support from a therapist. Take care of yourself and reach out for support. If you have questions, you can scan this QR code. It's going to set you up with a time to meet with our client engagement specialist, and he can guide you through a lot of these things and how we can help you as you go through the divorce process. That is all I have. I'm only 2 minutes over. I don't know that we had any, and then also you have our QR code. So if you need anything, reach out to us. We're here. And I wish you the best as you go through this process. Thanks for being with us today.